All right. Good morning, everyone. Welcome to the Abolitionist Visions and Intersections, a summit hosted by the American Library Association Social Responsibilities Roundtable, or otherwise called SRRT. SRRT believes the libraries and librarians must center social responsibility by recognizing and helping to solve social problems and inequalities to work for the common good. I just wanted to say my name is Deanna. I am a social worker at the Federal Defender's Office in Sacramento, California. Along with one of my social work interns, Parveen here, is helping me do some of the technology. I'm also joined in the sessions, the chat monitor is Catherine today, and the question and answer monitor is Rebecca. We have exciting three new speakers. Most of the sessions, not all of the sessions, will be recorded, and the recording will be on the SRRT website by early April. Please keep your cameras and mics off unless you are the presenter. And just as a ground rule, please be respectful and extend care and compassion to yourself and others during the session. You know, good self-care is always a good thing. This includes using first-person language when posing questions or sharing information in the chat. And during this session, please refrain by using dehumanizing words such as prisoner, convict, ex-con. And instead of language like that, we want to emphasize we want to humanize people by using such as incarcerated people, formerly incarcerated person. In my profession, we're always using justice-involved individual. Yeah, and then also, as a side note, we are not having our questions and answers till the very end, but please use the question and answer to pose any questions, and reserve that chat. In any resources and anything will be in the chat. So we hope and there's at least 10-15 minutes at the very end, and when the presentation is concluding, that we would be able to get to those questions and be directed to whatever presenter that you have the question to. And this session focuses on three different areas, but we will start, so the theme of it is lived experience and carceral realities and public knowledge. And what we're going to start off today is my friend and colleague from actually Sacramento. We're here at 8 o'clock in the morning doing this. Justin's been texting me this morning, and he will start with his presentation and about solitary confinement. And this talk will explore how solitary confinement marginalizes different cultures and demographics in the process that only can violate constitutional rights, but marginalizes people of color, women, children, and the mentally disabled. Justin, again, he's a patient navigator at BART programs. This is a medically assisted treatment program for people suffering with opiate use disorder. And he is a student at Reemerging Colleagues program at Sacramento. He is in a lot of the reentry groups and with me as well. And I am just very excited to introduce you to Justin. He has lived experience and he will give you a wonderful presentation. So here is Justin.
Good morning, everybody. My name is Justin, and before I begin, I'll just give you a little bit of my experience. I was released May 19th after doing 15 years in the federal system for a nonviolent crime. So since my release, as Deanna said, I'm involved in a lot of things that have to do with reentry and helping our communities kind of destigmatize what formerly incarcerated people are. There's still a huge stigma out there about us returning citizens and how we're perceived. And so I'm trying to break those barriers. So I'm a full-time student in college, and I'm a sociology student, and I took a class that on administrative justice and constitutional issues. So the history of solitary confinement can be dated all the way back to the 1780s, when social and prison reformers used isolation as a humane alternative to other forms of punishment like execution. Social and prison reformers believed that the silence in a solitary cell would allow the prisoner to reflect on their wrongdoings and lead to moral and spiritual reform and induce penitence. However, it soon became evidence that this practice was causing more harm than good. Prisoners were becoming depressed, anxious, panicky, apathetic, agitated, confused, delusional, and harming themselves. By the 1890s, this practice fell out of favor and stopped being used, only to reemerge as mass incarceration practices led to overcrowding, which led to increased violence. Commonly known as the whole, segregated or restrictive housing, solitary confinement is a form of punishment for those that are incarcerated when they, quote unquote, break the rules. They are isolated from the general prison population and kept in a cell for 22 to 23 hours a day. If I could have you guys imagine, for those that have smaller bathrooms, living in that bathroom with no sensory stimulation for 23 to 24 hours a day. These punitive measures are supposed to be for those that the prison has either deemed too dangerous for general population or for those that commit acts of violence. In reality, prison officials misuse this management tool for a wide variety of reasons that are oftentimes arbitrary and counterproductive. Some of these reasons are as simple as a lack of housing, simple rule violations, and prisoners that have crimes that are unfavorable. For example, sex offenses. Or even worse, they use this practice for those that question prison policies. Those confined in solitary confinement or segregated housing on an average spend upwards of 30 days, and in some, to most cases, years in conditions that are inhumane. The Eighth Amendment prohibits the use of cruel and unusual punishment. Many have argued that the use of solitary confinement violates this constitutional right. But because of the lack of clarity in this amendment, the U.S. Supreme Court concluded that while there is a risk of serious psychological injury to inmates, that risk was not sufficiently serious of magnitude to find a per se violation of the Eighth Amendment for all prisoners placed in long-term solitary confinement. Solitary confinement is known to cause or worsen mental illness, deteriorate physical health, and cause long-lasting social problems upon an inmate's release back into society. This in itself is a direct violation of the Eighth Amendment. Even worse, many held in prison suffer from pre-existing disabilities already, such as mental health conditions, and when placed in solitary confinement, lack the basic fundamental medical care and mental health care. We all know that the 5 basic needs that everyone needs to survive are food, water, shelter, sleep, and clothing. Solitary confinement by constitutional rule provides all these things, but what makes this practice unconstitutional is the cruel and unusual part of this amendment. Abraham Maslow defined human needs in the form of a hierarchy chart. These needs are self-actualization, the desire to become the one most can be, esteem, respect, self-esteem, status, recognition, strength, and freedom, love and belonging, which is friendship, intimacy, family, sense of connection, safety needs, personal security, employment resources, health, and property, and basic human needs, such as air, food, water, shelter, sleep, and clothing. While your basic needs are being met, the needs that help us socialize and thrive are not being met. Maslow argues that if prisoners in prolonged solitary confinement were able to belong, they would not suffer extreme psychological deterioration. Reforming solitary confinement would allow prisoners to belong, would lead to favorable outcomes, not only for the health and quality of life, but also for security concerns. I would be remiss if I did not mention that solitary confinement is also a 14th Amendment violation as well. The 14th Amendment states that no state shall make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States, nor shall states deprive any person of life, liberty, or property without due process of law. This amendment is supposed to limit the types of prisoners that can be placed in solitary confinement and the time prisoners can be confined. Many times prisoners are put into solitary confinement with no real or meaningful hearing. Prison courts have no oversight and are usually one-sided affairs where the person incarcerated is already guilty before giving the chance to prove their innocence. And in a lot of cases, prisoners are placed in solitary confinement before they're even afforded a hearing. Lack of staff and overcrowding ensure that these prisoners will stay in solitary confinement for months before they even receive a hearing. And then after that hearing, those months that they stayed in solitary confinement leading up to that hearing don't count. There are several groups that are marginalized by the practice of solitary confinement more than others. Women, for example, tend to be subjected to harsher disciplinary practices than men. Another reason women are placed in solitary confinement is retaliation. Women are often sexually harassed by guards, and when they complain, instead of an investigation taking place, they are removed from population and placed in solitary confinement. This is a management tool that not only protects the guards, but also decreases the likelihood that women will report harassment. Solitary confinement has also been shown to disproportionately affect people of color. Black people and Latinos are placed in solitary at rates far higher than white people. A recent study done by correctional leaders at Yale Law School found that while Black women make up 21% of the female prison population, that same group make up 42% of the female population held in solitary. This study also found that Black and Latino men were 8.2 times more likely to be held in solitary confinement than white men. This is just another example of how the new Jim Crow creates a huge disparity towards people of color. Last but by no means least is juveniles. The controversy of placing juveniles in solitary confinement is huge. Putting juveniles into solitary confinement can be highly detrimental to their growth and development. We know that the human brain is not fully developed and matured until someone is in their mid-20s. Placing juveniles into solitary confinement has shown to complicate that maturity, often leading juveniles to experience huge mental problems. Many juveniles speak of harming themselves, hallucinations, losing touch with reality, and thoughts of attempting suicide. Let us not also forget the physical side of placing juveniles in solitary confinement. With lack of proper exercise, this causes the body to develop medical conditions that would otherwise not be present on a body growing with proper exercise. Another problem with those that spend time in solitary confinement is the problems they face after release. Statistics indicate that those that spend time and those released directly from solitary are far more likely to reoffend. A study in Florida found that prisoners who were kept in solitary confinement for more than 90 days committed violent crimes at a rate 20% higher than general inmates put in solitary confinement. In Connecticut, the numbers were even starker. In 2001, 66% of prisoners released from general population committed new crimes within 3 years of their release. That percentage skyrocketed to 92% for those released directly from solitary confinement. Another byproduct of being kept in solitary confinement was mentioned earlier in my paper, and this has to do with mental health. Mental health problems are well documented for those that are placed in solitary confinement for prolonged periods of time. But what about after their release? The conditions of solitary confinement are horrible while incarcerated, but even more so for those when released. Many prisoners kept in solitary confinement complained of severe anxiety and PTSD-like symptoms. Because isolation is a huge part of solitary, many have challenging times adjusting to doing simple everyday things like shopping for clothes and deciding what to eat for dinner. They are often startled easily and avoid crowds and public spaces and seek out small confined spaces because those public spaces overwhelm their sensory stimulation. A study found that those who reported a history of solitary confinement were more likely to report PTSD symptoms than those without solitary confinement. This is to the tune of 43% versus 16%. As we move away from the harsh punitive policies of recent decades, our aim should not only to be cutting the rate of incarceration, but we also need to fix the conditions of confinement as well. Humans, we are social animals, but life in solitary is characterized by extreme social isolation and environmental deprivation. Solitary is not now, if ever, was reserved for the worst of the worst. There are other ways to not only discipline those that break simple rules, but conditions for those that absolutely must be in solitary confinement can be improved as well. Some of these steps can be banning solitary confinement for the mentally ill, using solitary for the least possible amount of time, allowing those segregated from general population more time out of their cells, instituting programming for those in solitary confinement. For example, education, therapy, access to legal materials, allowing those in solitary confinement access to media devices, such as TVs and radios, overhauling these procedures and creating oversight for the prison on the use of solitary. There is hope. Many states in recent years have begun to see the unconstitutionality of solitary confinement and have begun to reform their practices. There has also been legislation to set a cap on the amount of time someone is allowed to spend in solitary as well. As we begin to move to a harm reduction model rehabilitation, these steps are a start. Ending mass incarceration practices and solitary confinement allows someone to have the chance to function in society and give them the tools to succeed can only result in making our communities safer and upholding the functions of law. Myself, I have spent time incarcerated as well in solitary confinement. And what I experienced, and I can only speak from my experience, was the sense of isolation. And that sense of isolation is super severe. Your first couple days, it's not so bad, but when you start getting into 30 days and beyond, it starts to really test your mental capacity as a person. There are no resources in there for those that are in solitary confinement. You're dehumanized already by just the lack of material to read, even clothing to wear. And then just because you're there, you're already stigmatized by guards. And, they don't put guards in solitary confinement because those guards are officers that, can work with the general population. A lot of those guards are in that position because they have problems working with the general population. So you can imagine how they treat those in solitary confinement. It's just a very deplorable condition. And so upon my release, I got into this work, and because I really want to change these narratives eventually, for those that are justice involved and for those that are coming out and being formally justice involved. I really thank your guys' time for today and really appreciate this opportunity. Thank you.
Thank you so much, Justin, for sharing your experience plus that informative presentation. We'll definitely have room for questions at the end. I'm gonna introduce our next speaker, but I just want to make you guys aware that we're putting a pause on the recording for now, but it will definitely resume during the third presentation. But it is my pleasure. We like to introduce law versus practice, incarcerated people on a library access. We have two presenters here. This presentation will draw on first-person narratives by incarcerated people, writing about a lack of access to law and other library materials. Co-presenter Jason Rodriguez will speak from his experience as a law library clerk inside Attica Correctional Facility. So just to do a quick bio, we have Doran Larson, is Edward North Professor of Literature at Hamilton College and co-director of the Mellon-funded American Prison Writing Achievement. His most recent work, which we can put a link up, book is Inside Knowledge of Incarcerated People on the Failures of the American Prison, along with Jason sharing his experience, and he's a research associative and a former law library clerk, and he served decades inside the New York State prisons for the crime committed as a teenager. So we welcome Duran and Jason. Thank you.
Thank you for having me and for us and for being in this space with y'all. Just really briefly, I would like to point out one thing is that I'm returning citizen, formerly incarcerated individual at the age of 17, where I served almost 25 years inside of New York State prisons. And I often forget that being treated so inhumanely during my incarceration, I often forget that I am human. And sometimes I still kind of resort back to referring to myself as a prisoner or inmate. So just bear with me if that comes across in any of my talk today. I don't mean any harm. I'm still getting used to this process. So thank you for your patience. Yes, so without further ado, grateful to be here. So I entered prison as an incarcerated individual at the age of 17 with a 7th grade education. And during that time, I was lost as to challenge my conviction. I knew that there was an injustice that occurred in my case. I just didn't know how to challenge that. And through talking with other incarcerated individuals that guided me to like law library access, I started trying to study the law, but I realized I couldn't really read and write. So first I had to understand how to read and write properly. And then I started to study the law to challenge my conviction. In that process, I mainly started studying the law to free myself from that conviction. And in that process, I came across many folks who were also illiterate and didn't understand the law and had real difficulty in navigating the system and trying to advocate for themselves as well as others and their convictions. And so I began assisting incarcerated individuals with the law as I began learning it and challenging not only the confinements of misbehavior reports, but also challenging their confinement for convictions through the appeals process. And for many of those cases, I was successful in overturning a couple of convictions and at the same time challenging DOC's authority in filing false misbehavior reports and rectifying those injustices, oftentimes at the cost of being abused or punished for trying to help folks assert their rights. In Bound versus Smith in 1997, the Supreme Court ruled that prisoners have a constitutional right to access to the courts. Specifically, the court held that states are required to provide indigent incarcerated individuals with access to legal materials, assistance, and facilities to prepare those legal documents. 2 decades later, a case by the name of Lewis versus Casey, 1996. In this case, the Supreme Court further clarified that Bounds versus Smith decision, stating that incarcerated individuals' constitutional right of access to the court requires prison authorities to provide adequate law libraries or adequate assistance from persons trained in the law. This includes access to legal materials, assistance, and facilities necessary to effectively challenge their conditions of confinement or other legal issues. 3 decades later from Lewis versus Casey, in granting that access and recognizing we have that constitutional right, the access was meaningless. While we have access to law libraries, the majority of us don't have proper training and/or adequate time in understanding how to use or access that right. Thus, our access to the course oftentimes become meaningless. Problems with that access. The first problem is proper training in law library materials. First off, while I was in prison, I not only worked as a law library clerk, which is known as a jailhouse lawyer, but I also taught the research class by facilitating that program to other incarcerated individuals. And the materials that they had given us to kind of teach from was a legal research book that was outdated and written in 1985. When I started teaching from that course, it was like 2001. And we were teaching that course all the way up until I left prison in 2021. And I often had at times kind of supplemented that by reaching out to law schools and asking for their law student curriculum so that I can kind of incorporate that. And I came up with my own curriculum to kind of teach folks to keep them updated to the changes in the law. Because as we know, if we have outdated materials, like any criminal case or civil case or any case that's detrimental to challenging our confinement, if we don't have those updated materials at the time that we need it, that can often lead us to not effectively litigating our claims and being denied, whether it's in court or through prison authorities, because our research materials are not up to date. Another thing that's happening is that the courts did go digital, and I think 2007, where they started providing computers to many of us in prison so that we can have direct access to like an internet service that would teach us law through LexisNexis. But oftentimes when they brought that hardware in, a lot of us didn't even see a computer before. I myself was in prison in 1997. I had not even seen a computer or had access to one. So it was very difficult for me to even look at the computer and know what it was, for me to even access it and try to utilize it. And that was one thing that was really hard on myself and many other folks. And while they brought in the computers, they did not provide any adequate training to us to how to use those computing. So again, that access became meaningless. On top of that, another problem that kind of I guess hinders us from litigating effectively or challenging our confinements is the limited time that we had within the law library services. We were only allowed access to a law library facility from 1 to 2 hours once a week at best. And that's really insufficient time to research and prepare any legal motions, let alone understand how to navigate a system that many of us wasn't familiar with. So, and on top of that, what compounded the problem was, depending on what mood the guard that was escorting you, because all of us had to be escorted to the law library at certain times of day, depending on that guard's mood, our access might be delayed an hour where we would only have 15 to 20 minutes. And as soon as we sat down to research or read our books, it was time to leave the law library. One of the things I noticed by being a jailhouse lawyer and helping illiterate incarcerated individuals navigate the prison system and the legal materials myself was, I feel like one of the solutions can be to afford proper training in the research methods, and possible with the help of law students, where we can kind of get law students that come into the facility to teach updated courses and the proper way of understanding and litigating law. Another way is New York State has a tablet program, where on this tablet program, we could be allowed access to law library materials throughout the day and night, where there would be no need to actually attend a law library facility, where we can now understand the materials that we have through the proper training of law students and other materials, and at the same time have unlimited access to that material where we can take our time to research the law and better advocate for ourselves. I feel like that would empower us and make it more efficiently for us to challenge our confines of conviction and sometimes really unjust conditions within the prison setting. These problems and many others, I feel, are not unique to New York prisons, but kind of speak nationally throughout all prisons and institutions. And with that, I'll turn it over to Doran. Thank you.
Thanks, Jason. And thanks for everyone who's here and everybody who's put this meeting together. I am going to broaden the discussion, but in some sense, I'm simply going to repeat and try to demonstrate the significance of the kind of work that Jason has done inside and that other incarcerated people are doing from inside prisons. So in Black Reconstruction, W.B. Du Bois documents the work of enslaved people to liberate themselves rather than waiting on the efforts of Northern whites. Continuing that legacy, incarcerated people today are the inside agents of prison abolition, in part due to their efforts to seek both procedural and substantive justice from the courts. In Bounds versus Smith, as was mentioned, the U.S. Supreme Court declared it unconstitutional to deny incarcerated people access to law libraries. Yet first-person testimony by people incarcerated today documents the lack or unreliability of access to law library services in the U.S. In the American Prison Writing Archive, the largest and first fully searchable digital archive of nonfiction essays and poetry by currently incarcerated people, the breadth of such testimony is telling. From states across the nation, incarcerated writers attribute library inaccessibility to exactly the things that Jason has spoken about. Staff decision-making, arbitrary staff decision-making, administrative and structural blockages, and they document retribution for their temerity in fighting their cases. That is, everything that Jason has said, we can apply across all 50 states. The slides I'm going to share, let me put this up, are just a sampling from testimony in the American Prison Writing Archive, and they are drawn from a curation on essays about library access that I put together actually for the ALA in seeking to advocate for legislation enabling information on library access to incarcerated people. I don't mind if you multitask, go to prisonwitness.org while I'm putting these up because I'm just sampling from exactly the same source. If you go to prisonwitness.org and you click on the Explore the Archive and search LIBRAR, you'll find that there are 480 essays in the archive that deal with libraries and librarians. So I'm just going to quickly read through just a few examples here. The facility I'm in has the smallest in the state's law library, about 11 feet by 8 feet max capacity, 3 inmates and 1 clerk. Inmates work elbow to elbow, packed like a can of sardines. 99% of the books in this law library are outdated and insufficient to developing modern legal work. And again, as you will see, most of the points that Jason made are going to be echoed in these writers too. Typewriters are gone under the control color of security of institution, despite having permitted them for many years, law library access, and some high security institutions have degenerated as retribution for prisoner lawsuits for equal access. In the law library, there are 4 computers equipped with only Westlaw.com for legal research. In the main library are 4 computers equipped with Microsoft Word. These resources must serve the needs of 850 plus prisoners. The documents produced may be deleted or modified at any time without notice. As of October 1st, 2017, there is no longer paralegal here to help us with our legal work. The law library is no longer being updated with legal materials because prisoners have tablets. The prison administration is using the e-tablets as an excuse to cancel library and regular library, keeping us locked up. So the suggestion that Jason makes I think is a very, very good one about having e-access, but obviously that can also be used against incarcerated people. Like almost everything that seems like a progressive movement turns around and ends up being used against incarcerated people. There's no library in this facility. The general library is permitted but once a week when available, then for only an hour and a half. Sadly, jailers and prison officials have become emboldened by too many court rulings favoring these autonomous institutions. And finally, the management have stolen my legal papers that I sent to the law library to be copied, typed, and denied me law library access to sabotage my PDOC cases and post-conviction relief. In April 2018, after I filed a complaint in the federal court on the theft of my papers and denial of library access, I was targeted for more reprisal. I was denied food, harassed in the shower by male staff, hygiene tossed out, ambushed with chemical weapon warfare, placed in property restriction, belongings taken and confiscated, and issued 14 disciplinary reports. An officer actually threw my tray on the floor, glared at me, and then walked off to report that I had thrown the tray I had never touched. I was not fed twice this month and threatened with pepper spray more than once on camera while denied basic necessities. And it was, as mentioned earlier, the excessive punishment that goes against women is evidenced here as well. Now I'm going to have some other slides, but I just want to read a short section before I move to those. So court decisions and regressive legislation are necessary, but they are often the case that they hit the outside of prison walls, but don't cross over. Prisons were conceived by Benjamins Rush and Franklin and others as much to keep the public outside as to keep convicted people inside. From its very beginnings, this ceiling has been nearly hermetic, and in particular against the law under a constitution that sanctions slavery and through post-war court decisions has rendered the Eighth Amendment practically moot. In this environment, first-person witness to carceral practices is not only our most vital source of information about actual practices inside prison walls, it is the evidence of the courage of incarcerated people in fighting for their own liberation and their frontline efforts for abolition, and to become leaders in thinking about the distance between what prisons should do and what's happening to bodies caged by the law. The archive grew out of, and I just want to give you a sense of the breadth of the work that's coming out of these prisons and the work that's being done there by writers inside. The American Prison Writing Archive grew out of a book collection that came out in 2014. It was 71 essays from 27 states. It's still the largest, in-print collection of nonfiction essays by currently incarcerated people. The deadline for that book passed in 2012, but essays kept coming and coming and coming. The archive now holds the equivalent of 66 volumes, the size of Fourth City, and it grows by 9, depends on the volume we're getting each month. In some years, actually 12 volumes per year. We have at this sitting the equivalent of 62% of all of the known, in terms of word count, 62% of all the known narrative on North American slave, for North American slave narratives. That is to say, within a predictable number of years, there will be more direct first-person witness to the experience of mass incarceration than exists for slavery. And that's just in the American Prison Writing Archive. And as you know, there are others as well. We're now working on helping the public appreciate the value and the sort of the essential, resource that the writing of incarcerated people is, by putting together book volumes which curate out for certain topics. The first is a book that just came out in January, as mentioned. And in this book, I draw evidence from the archive to demonstrate how prisons not only do not achieve their 4 cardinal rationales for being, but actively defeat them. We also have volumes planned with guest editors. The first of those will be by Elizabeth Hinton and Elsa Laura at Yale on violence inside, again, all drawn from direct first-person evidence from the archive. The second volume, Heather Ann Thompson, the Pulitzer Prize winner on conditions and resistance. Ken Hartman and prison-bound California editors are currently incarcerated on prison and the Golden State. And Michelle Alexander on the inside meaning of liberation, freedom, and justice. So I'll stop the share there. As Du Bois writes of enslaved people who refused to labor during the war, quote, "It was a strike on a wide basis against the conditions of work. It was a general strike that involved directly perhaps 500,000 people. They wanted to stop the economy of the plantation system, and to do that, they left the prison," unquote. Prison work strikes in this century have sought to end carceral slavery. Before, during, and after such strikes, those seeking access to constitutionally guaranteed and institutionally denied access to law library resources continue the labor of seeking liberation from inside, searching, as poet Michael Hogan wrote from inside in 1975, quote, searching, quote, "the veins and the arteries of the corpus juris," unquote. We would do well, among other abolitionist tactics, to aid these efforts. Thank you very much.
Thank you so much. I can definitely, by looking at the chat and have the experience. Thank you, Jason, for sharing your powerful story. And Zoran, I appreciate you again being a sport, giving us that informative presentation. Right now, we are going to start with a question and answer. And I think just because You guys have last presented. I think we're gonna start with Jason. Is that okay? I'll put you in the hot seat.
Yeah, no worries.
Okay, so Jason, there's a question. Is there a librarian in the prison library at all, or is it left to clerks to assist others without professional help?
Yes, so there's only incarcerated individuals as clerks. There is no like outside source that comes in and helps to facilitate that at all.
So you're saying you have to be pretty self-motivated?
Yeah, you have to be pretty, I'm sorry. Yeah.
No, don't be sorry, Jason.
Yeah, you have to be pretty self-motivated. I mean, it took a lot to me, and anyone litigating their own case is like stressful. It's like it's what a predecessor like reminded me of is like being inside of a safe, trying to crack the code from the inside before the air runs out, is how best I can put it. Yeah.
Yeah, well, that's a
I
good.
can also, I can add to that uh, prison libraries, general libraries often have librarians there, people who assign that job, but they're not there because, they have an MLS degree, right? They're there because it may be the next move they want to make and, moving up a hierarchy, or they want to just change from another job. So they don't necessarily have a lot of training as librarians.
Well, thank you for that. But speaking, Doran, we have a question for you as well. So in addition to potential courses led by law students, would reference by mail service by public libraries be useful in supporting access to law or legal materials? Or do you think that would be greatly censored before getting in the hands of incarcerated people?
I can say what's I think is true, and Jason, correct me if you feel, that I'm wrong about this. It depends on the facility you're talking about, and it depends on the person who's actually on staff in the mailroom on the day, right, in which those materials come through. Though we think about the prison system as a system, it is remarkably unsystematic. It's really, as Jason mentioned, about the mood, whoever the staff are at any particular moment. Legal mail technically is supposed to be the one form of mail that remains private, and that's a rule that's violated on a regular basis. I have actually utilized students at Hamilton College to generate research for students in a college program at a local prison that I organized after putting together the program at Attica. So that was facilitated through a college program, and the program and the facility was supportive of that program, and so they allowed that research, those materials to go in, right? But unless you have some sort of official cover for the transfer of information, again, it's really haphazard.
Well, thank you so much for that. Did somebody have their hand up and now they want to make
It
a
was an
comment?
accident. I was chatting and I went up by accident. Sorry.
Oh, no, totally fine. I just want to make sure I'm not missing somebody's question or comment to Doran. Then we will go on. Sue, are you ready to be in the hot seat for a question?
Sure.
All right. So we have one question here. Do you think that there is a correlation to banned manga between marked as sexually explicit that is actually banned for themes like rebellion, anti-war, anti-fadism, etc.?
So the question is like there is a correlation between the like sexually explicit materials and the war and infant SRSR. Like sorry, I didn't know. I understand the question well enough.
Ashlyn, not trying to put you on the spot. Do you want to reiterate what that means? Or maybe they, them are not here.
Not here.
Um,
But I can briefly answer, like, I don't know, I can answer the question accurately. But Like sexually to me, based on my observation and then analysis, like with my assistant, it seems like there is sexually explicitness is just the reason they want to put like but it's unsure that the content is really censored because it's sexually explicit or because of other visual reasons like but it's easy way to put. And there is another reasons that has been used a lot but less than sexually explicit is security threat, but they overlapped each other a lot. So it's like if the material is rebellious or like fantasy driven or something like it depends on the it depends on the mailroom situation and staff members availability and their understanding about the material. There is no like one clear standard to like put certain content is one category or the other.
Thank you so much for answering that question. We appreciate that. I think, again, we got 1 minute here and we're doing excellent on time. So I just want to thank all the presenters for today and thank you for attending. Our next session today that will start at 11:20 Central Time is participatory workshop, Rooted Resilience, Fighting the Polymigra. Again, it will start at 11:20, the same Zoom room. So we encourage you to stick around today. And again, thank you for the 4 presenters. We really appreciate your time and you guys expressing all your expert knowledge and lived experiences. You all have a wonderful day. Thank you so much.